you for joining us for today's online talk, which we will be starting shortly at 3 o'clock. So for those of you who are here early, thank you so much for waiting patiently. While you're waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody. Thank you so much for joining us for today's online talk. It's entitled Applying for Planning Permission, Overcoming Approval Challenges in Project Development. My name is Jasmine Wee and I'm an associate with Mawing and Associates, and I will be your moderator for today's session. So before we start today's talk, let me just introduce the firm and talk about what we do. Mawing and Associates is a mid-sized law firm that was founded in 1985 by Dr. Mawing. Our able team today comprises of 33 lawyers and a support team of 30 people. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration. We are a dedicated employment and industrial relations team, as well as a department focused on servicing the needs of individuals and families. As for our practice groups, this indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were broadcasted live. But with the COVID-19 MCO, we have since moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. So before I continue, I'd like to remind you all that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have two speakers for today's talk. Allow me to introduce Denise. She is a partner of our firm. She leads the land dispute team of the firm, and she graduated with a Bachelor of Laws from the University of London. She was admitted to the Malaysian bar in 2015. She is well versed in planning, development, infrastructure, construction, as well as environmental laws. She was also named as a next generation partner in 2024 by Legal 500 and was also named a rising star in 2022 by the Asian Legal Business Malaysia, which is in partnership with Thomson Reuters. Next, we have Mr. Joseph Khor, who is an associate in our dispute resolution, corporate, and employment industrial relation departments. He has a Bachelor of Laws from the University of Malaya. He regularly acts and advises on all levels of the Malaysian courts in land-related disputes. His areas of focus are in land disputes, which include land acquisition, planning, and development laws, as well as administrative law, corporate, in terms of company litigation disputes, and employment disputes. Our top points today will be overview of the planning permission process, environmental and social impact assessments, case studies and recent court decisions, as well as the challenges and any practical tips for successful applications. Just as a reminder, we'll be having a Q&A session after the talk. So if you have any questions, please do not hesitate to post it up in the chat and we will address them in the end.
Thank you, Jasmine. And thanks everyone for taking time off to attend our online talk this afternoon. As mentioned by Jasmine, we will cover 4 talk points in our talk today. The first is the overview of the planning permission process. I will be taking everyone through a very high level of bird's eye view of the planning permission process. I will raise a few points that are pertinent for everyone to consider. And then we will move on to briefly touch on environmental and social impact assessments. Now, these two things are recent amendments or recent insertions brought about in relatively recently to town planning to facilitate for the recent uprising of environmental awareness. And I believe the attendees here today would also be aware of some high-profile court decisions that have touched on such matters. After which I will pass the floor to our partner, Ms. Denise Phang, who will take everyone through case studies and recent court decisions and highlight some key important points there. And then from those court decisions, we are able to see a few challenges as well as suggest a few practical tips for successful applications for planning permissions or in overcoming the challenges that we face. So whether you are a developer or in-house legal counsel for a developer, or perhaps you are an architect or even a concerned landowner in relation to planning permission and approval of planning permission or rejection of planning permission, we hope that we can provide some insight into the legal aspects of planning permission through our talk this afternoon. So allow me to move on to our first talk point, which is an overview of the planning permission process. Now we will go through a few legal provisions as I'll show later. First, let me start off with the legislation or the laws governing planning permission. There are 2 main pieces of legislation that govern planning permission. So the first one is the Town and Country Planning Act 1976. I will refer to it as the TCPA, and the subsidiary legislation under the Town and Country Planning Act, which includes orders, rules, directions, and so on and so forth. The next is the Federal Territory Planning Act 1982. It's quite similar to the Town and Country Planning Act, but it's special in the sense that it only applies to Kuala Lumpur. And it's interesting to note that while it does say in the name, the Federal Territory Planning Act, it only applies to Kuala Lumpur due to the definition of the Federal Territory inside the Act itself. Whereas for the Federal Territories of Putrajaya and Labuan, it is governed by the Town and Country Planning Act as well. But as we'll see as we go along this afternoon, the provisions are quite similar with minor differences in the provisions here and there. But overall, they are similar generally, and the principles that apply across these 2 pieces of legislation are largely the same. Now, while the 2 pieces of legislation I mentioned govern planning permission specifically, it's interesting to note, and it's important to note that these are not the only legislation governing construction and development. So apart from the Town and Country Planning Act and the Federal Territory Planning Act, there are other pieces of legislation involved when it comes to development and construction, such as the Street Drainage and Building Act, the Environmental Quality Act, and etc. So developers, architects will need to bear in mind all these other pieces of legislation I'm sure you are aware of, that you need to take into consideration when planning a construction or a development. But our primary focus today is on the issue of town planning and planning permission specifically. So planning permission is very important because under Malaysian law, you cannot carry out a development without planning permission. So that is provided for under Section 19 of the Town and Country Planning Act, as well as the Section 20 of the Federal Territories Planning Act. So the development, the specific wordings of the provisions vary between the 2 acts, very, very slightly, but in essence, they are the same. Then the development means the carrying out of any building, engineering, mining, industrial, or other similar operation in or over or under any land, change, or that's one, or change in the use of the land and building. We'll come to that in a bit, what we mean by use of land and building, or any part thereof, or the subdivision or amalgamation of lands. There are exceptions to this. So you can see that this provision governs a very wide spectrum of works, to put it very generally. So a lot of works, as you can see, require planning permission and require the approval. When we say planning permission, in colloquial terms, it means requires the approval of the local authority. For example, if you live in the Ampang area, it's MPAJ, Majlis Perbandaran Ampang Jaya, or if you live in KL, then it's KL. If you live in Penang, for example, then it's MPPP. So these are the authorities involved in approving planning permission. There are exceptions to works that require planning permission, and they are found in sections 19.2 of the TCPA and section 22 of the FTPA. Now, I won't go through everything specifically, but these exceptions, for example, include necessary works for maintenance, improvement, or alteration of buildings, which affect only the interior of the building. For minor works for construction of awnings, this is for Kuala Lumpur, or sewerage, for carrying out of excavation in lands, or rather including wells made in the ordinary course of agricultural operations. Of course, this is limited to areas zoned for agricultural purposes only. There are many exceptions under sections 19.2 and 22 of these pieces of legislation, which do not require planning permission. However, for majority of the works carried out, major works, all these works require planning permission. So the planning permission is important mainly because the overarching principle is that the use of land and buildings must conform with the development plans. So development plan is a general term used in both pieces of legislation to describe either a local plan or a structure plan. Now, these plans are basically plans that if you are a developer or an architect, you would have seen that these plans are areas where the areas in the region are marked with colors, and each color, they will have a legend specifying that this is zoned for what, agriculture, commercial, so on and so forth. So in the grand scheme of town planning, the use of lands and building must conform with the development plans, being either the local plan or the structure plan. And if there is to be a deviation or material departure from this local plan, as we will see later, planning permission is required. And the surrounding landowners, neighboring landowners must be given a chance to be heard on their objections to the change in the use of the land or building. So a lot of us may know that when we own a piece of land or building, the title to the land will have a category of land use for agricultural, industrial, or residential. These are broad categories. But zoning is more specific. And the federal court in MMC Tepat Teknik basically held recently that zoning prevails over the category of land use because it's a more specific law when it comes to town planning and planning permissions. So although the category of land use may say one thing, but if the zoning of the area is more specific or limits what you can do on that land, then the zoning will prevail over the category of land use. A brief overview of the planning permission process is as follows. So first is the application stage, where you make an application for planning permission to the local authority, along with the information, documents, plans, fees, development proposal report, as prescribed by the local authority. So in this process, there will also be involved environmental and or social impact assessments, which we'll come to in a little bit more detail later. So if there is no local plan or no development plan, or if there's no local plan, or if there is a material deviation from the local plan, then the neighboring landowners must be given a right to be heard, meaning they must be given the opportunity to object to the planning permission application and be heard by the local authority. So after considering the planning permission application, and if there are any objections required, after considering and hearing the objections, the local authority has to make a decision on the planning permission. And some of these decisions require further consultation with the National Planning Council, some don't. And the planning permission, they decide to approve the planning permission, grant the planning permission, they can decide to grant the planning permission with conditions imposed, or they can refuse the planning permission. If they grant the planning permission with or without conditions, the planning permission is generally valid for 12 months, unless extended further. And the party that is unhappy with the decision of the local authority has 1 month from the date of the communication of the decision to lodge an appeal to the Planning Appeal Board. Now, there is a slight distinction in the appeal processes here. We will come to that in a bit, between the Town and Country Planning Act and the Federal Territories Planning Act. Appeals. Section 23 of the TCPA, which applies to most of Malaysia, provides that an appeal must be lodged within 1 month from the date of the communication of the decision by an applicant for planning permission or a person who has lodged an objection. So this is a wide spectrum of people that are covered by this appeal provision. So in Kerajaan Negeri Selangor against Berjayaland Berhad, the Court of Appeal recently in 2022 held that you cannot file a judicial review unless the appeal process has been exhausted. Otherwise, the judicial review would be. But it is interesting to note that for Kuala Lumpur under the FTPA, it says here the provision reads within 1 month from the date of communication of the decision, that's the same, by any applicant aggrieved by the decision of the commissioner in refusing the application. So for Kuala Lumpur, there are cases at the moment based on the current state of the law. These cases, these court decisions seem to suggest that objectors, because if you contrast this with the previous provision under the TCPA, which covers a person who lodged an objection, here it does not say appeal by the objectors, so by the applicant only. So there is a slight distinction here, and cases, court decisions seem to suggest that objectors, people who have lodged their objection against the planning permission, can file a judicial review without appealing to the appeal board first. This one such example is in the famous trellises case involving Rimba Kiara. And we will come to that. We'll expound that a little bit more in the case studies. And one important point to note is that written directions under Section 21(3) of the Town and Country Planning Act, these written directions are not appealable. So after submission of a planning permission application, the local authority may come back with such written directions that require compliance by the applicant or the party applying for the planning permissions. Now, this is not a decision, at least in the eyes of the court, it's not a decision by the local authority to either accept or reject the application for planning permission. But this is directions given. And in Sri Bangunan Sdn Bhd against Majlis Perbadaran Pulau Pinang, the federal court held that these directions are not appealable. So you can't appeal these directions. You can only appeal once there is a confirmed decision to either grant your planning permission or grant the planning permission with conditions imposed. So meaning that the planning permission is granted, but there are certain conditions imposed on these planning permissions. Or the third category is that the planning permission is refused outright. So in these three conditions where there is a definite decision by the local authority, then you can appeal to the appeal board. But if it's just written directions, these written directions that require compliance under Section 21(3), these cannot be appealed. And if you don't comply with these written directions, then the planning permission application is deemed to be abandoned under Section 21(5) if not resubmitted in the prescribed time. So if the planning permission application is not resubmitted with compliance with these directions within the prescribed time, then it's deemed to be abandoned. So this is the decision of the federal court in Sri Bangunan Sdn Bhd against Majlis Perbadaran Pulau Pinang. So appeal is one avenue interested parties, the applicant or objectors can take when a planning permission is either approved or rejected. And the other is judicial review. So in the case of the Town and Country Planning Act, this comes after the appeal. In the case of Kuala Lumpur, this can be done after a decision has been made by the local authority. And judicial review needs to be filed within 3 months from the date when the grounds of application first arose or when the decision is first communicated. So there's a strict timeline in terms of 3 months here. The courts are quite strict towards this 3-month timeline because it goes to the issue of jurisdiction of the courts. So within 3 months, you have to file a judicial application in the High Court And the grounds which you could use is illegality. For example, if it does not comply with the local plan, that is a ground that can go under illegality. Irrationality or unreasonableness. For example, if the planning permission application was not properly considered by the local authority, or they took into consideration factors that they should not have considered, these come under irrationality, unreasonableness, which is a ground in which you can seek for the court to quash the decision of the local authority. Procedural impropriety, breach of natural justice, and bias. Most oftentimes, this ground is raised by objectors to the planning permission application to say that they were not given a right to be heard when there is a material departure from the local plan, or where there is no local plan, they were not given a right to be heard or not informed. Legitimate expectation. In other words, basically, similar planning permissions have been granted to other developers under similar circumstances. So I have a legitimate expectation for mine to be approved as well. That's one. And proportionality, which is maybe perhaps the conditions imposed are too stringent. But proportionality and legitimate expectation, a lot of times, weaker grounds compared to the three above. So in essence, that is the process, an overview, bird's eye view of the planning permission process, from application to what you can do, whether after your planning permission application is approved or rejected. So an interesting topic to touch on in recent years is the role of environmental and social impact assessments. So if you might have heard of the cases of Sunrise Garden or the Rimba Kiara case, although the federal court in those cases did not dive very deeply into the issue of environmental and social impact assessments, it did touch on the environmental impact that will cause to the surrounding environment if these developments were approved. Environmental impact assessment, it's not baked into the Town and Country Planning Act, nor is it baked into the FTPA at the moment. But as we'll come to a bit later, social impact assessments are baked into these pieces of legislation now with recent amendments. So Section 34 of the Environmental Quality Act provides that environmental impact assessments must be done for prescribed activities. So these prescribed activities, those that are stated in the Environmental Quality Prescribed Activities EIA Order 2015, and are listed out in the first schedule and the second schedule to that order. So in general, the first schedule activities pertain to activities that do not require public display and public comment, unless otherwise instructed in writing by the Director General of the DOE. Whereas the second schedule requires public display and public comment. But the activities in these two schedules are about the same, just to differing degrees. I can have a moment to share these schedules so we can go through them briefly. So now this is the first schedule. The second schedule, the activities are about the same, just to varying degrees as I mentioned. So for agriculture, land development schemes covering an area of 20 hectares or more, but less than 500 acres. I won't go into detail, but generally we can see as I slowly scroll, aerodomes, drainage and irrigation, fisheries, forestry, chemical industries, cement industries, lime industries, petrochemicals. There's quite a comprehensive list for 4 pages long. That these activities do require environmental impact assessments to be submitted. So in considering a challenge to planning permission, the courts would also consider environmental impact assessments, such as in the Sunrise Gardens case. But as I mentioned, the federal court didn't go very deeply into whether or not the EIAs were complying with the Environmental Quality Act. It did touch briefly, but it's more of a general principle thing. Social impact assessments are similar, but baked into the Town and Country Planning Act. So far, we have not seen any such provision break into the FTPA yet. But essentially, for the Town and Country Planning Act, which covers most of Malaysia, there is a requirement for social impact assessments for certain types of development. And this can be seen from Section 20B of the TCPA. There are some activities where the federal and state governments must seek advice from the National Physical Planning Council on a development proposal relating to A, coastal reclamation, including reclamation for the construction of a jetty or beach rehabilitation. So this requires the development proposal to be submitted with a social impact assessment. Or B, any construction of a major national infrastructure, including airports, seaports, inland ports, railway transportation networks, highways, power stations, dams, and toxic waste disposal sites, and other infrastructure of national interest determined by the council. So in these kind of activities, there is a requirement for the development proposal to be submitted with a social impact assessment. Now, if I can just briefly share a sample of social impact assessment. As you can see here, there are some overlaps with an environmental impact assessment. So you can see there's a project background, location, the affected lands that are neighboring the project site, right? Another thing perhaps you want to look at or bring at the attention of the attendees today, there are guidelines by the Department of Environment on EIA consultant registration scheme and the environmental impact assessment guidelines in Malaysia. So these guidelines are helpful in developments that require environmental impact assessments or social impact assessments. So while there have not been any reported cases so far, to the best of our research and knowledge, that have turned, or a critical point in those cases being the absence or the presence, or whether the social impact assessment was conducted properly. So far, no major cases that are reported. There have been cases, but they're not reported, that have turned on this at the moment. And we'll definitely, perhaps we will be highlighting these cases in our articles, so you can look out for our articles as and when they come up. But for now, it is a requirement, a statutory requirement, for a social impact assessment to be done for these activities, these major activities, if it concerns the planning permission for these activities as prescribed under Section 20B of the TCPA. As I mentioned earlier, there's no similar provision in the FTPA. However, the case of Muhammad Yusof bin Abu Bakar and another against Dato' Bandar Kuala Lumpur seems to suggest that an SIA is needed. So Muhammad Yusof was held an SIA along with other technical reports must be provided to the objectors before the hearing of the objections. So the court did go into a little bit into the social impact assessments, but in this case, the critical factor deciding this case was that these technical reports were not provided to the objectors before the hearing of the objections. So the objectors did request for these documents, the technical reports, the SIA in particular, to be provided, the technical reports to be provided, but the technical reports were not provided to them. So in this case, the court said that there was unfairness in terms of procedure by not affording the objectors a proper right to be heard because they were deprived of the information to be able to go and mount a informed objection, or an objection that is informed with all these technical reports that enable them to identify the specific issues that they need to object to. So in this case, the Court of Appeal held that the failure to provide an SIA along with technical reports can amount to the planning permission being invalid. So I just end with the last one. In addition to, this is 21A of the TCPA, in addition to the documents and plans required to be submitted for planning permission, the applicant shall submit a development proposal report which shall contain the following. One of it is the analysis of mitigation measures for the social impact and other impacts as determined by the local planning authority. So this ties in with the previous provision earlier in relation to the developments requiring SIAs. So this SIA will obviously come from the applicant, which will be submitted to the local authority and then subsequently submitted to the National Planning Council. So this is the points on environmental and social impact assessments and the increasing awareness that the courts, the public have towards such EIAs or SIAs. And we can see a trend that these documents, the social impact assessment and EIA, is slowly getting a bigger and bigger importance in the eyes of the law and in the eyes of the court. So we can expect the trend going forward to be where disputes concerning planning permission go to the courts will be looking at SIAs and EIAs. So that is all for the points that I would like to present, and I will gladly hand the floor over to our partner, Ms. Denise Phang. Denise, over to you.
Thank you, Joseph. Thank you very much. Well, Joseph has pretty much covered everything. So I will be taking everybody briefly through recent case court decisions and also some case studies. We'll be using them as case studies. All of the information will be in our slides already. Now, these cases mostly are judicial review cases, and I think Joseph has also covered this previously. Judicial review case is a proceedings, is a two-stage process and it usually starts at the High Court.
So there are two stages. One is the leave stage and one is the substantive stage. Leave stage, what we normally lawyers in layman terms, it's called permission stage. So basically you are going to court, you're asking for permission to start your case against an authority. So judicial review proceedings are special in the sense that you want the courts to review decisions made by certain authorities, public authorities. So once the court grants leave, which grants you permission to proceed with the case, then you come to the substantive stage where the courts will look at the merits of your objections or your application. And just to bear in mind again, very stringent rule, the judicial review proceeding has to be filed within 3 months from the date when the grounds first arose or from the date where the decision of the public authority is communicated to you. Very strict. So in some cases, we even advise our clients to engage or actually seek legal opinion much earlier before decisions are announced. So that will give you more time to prepare your case if or in the event that you would have to challenge that decision. In moving on, our first case study is the case of Pembadanan Pengurusan Sunrise Garden Condominium against Sunway City. So this is a very recent case, 2023 case, where the developer, Sunway, applied to the local authority of Pulau Pinang for permission to develop a land for a housing development project. Unfortunately, this residential project is actually on hill lands. And under the Penang Structure Plan 2020, they do not allow, actually prohibits development on hill lands. So basically you cannot develop hill land because it's too dangerous. It carries a lot of risk. So under the structure plan, it is already prohibited. However, the local authority have actually issued a special project guideline and then granted planning permission for the developer to go ahead with the development. Now, just to show everybody the location of this proposed development of the land is shown in color. So red means that it's very high and very hilly, and then the level will slightly go down to green and then subsequently blue. So blue is basically flatlands where there is no prohibition on development. So Sunrise Garden, the proposed development, is indicated on this map with the white arrow, and it's actually greenish blue. So it's on the border of flatland and hilly land. But unfortunately, again, it's like about 40% of the land is hilly. So it's very hard to develop. Now, of course, the neighboring lands objected to the planning permission granted. And at the end, and this case went all the way up to the federal court. And the federal court held that planning permission ought to be quashed because these special project guidelines amounted to a variation or alteration to the structure plan. So under the Town and Country Planning Act, the structure plan can be amended and can be re-gazetted. But problem is it must be done before any planning permission is granted. If let's say you want to develop a land, you would want to apply to the state authority or the local authority to amend either the local plan or structure plan. Then only you put in your planning permission. But if you put in your planning permission and it's approved before the amendment of the structure or local plan, then it's conflicting. And like in this case, your planning permission will be subject to challenge. And in this case as well, the federal court held that where these special project guidelines do not comply with the structure plan, the planning permission is null and void. So it also special mentioned that the land title does not need to identify the land as a hill land. As long as the land is hilly, then the prohibition in the structure plan would apply to prohibit hilly land development. Okay, so this is the case of Sunrise Garden. Next, this is another federal court decision in MMC Tepat Teknik. So in this case, land was actually categorized for industry with an express condition for heavy industrial. And this is in conflict with the residential zoning under the local plan. So in this case, the court held that zoning prevails over the category of land. So normally we have two categories of use. One is stated in your land title and one is stated the zoning would be in the local plan. In this case, the court held that zoning prevails over category of land use. So you can follow the zoning, even though your land title says heavy industry, but if the land is zoned as residential, then you can use it for residential purposes. Now, the third case, I think Joseph mentioned earlier, the famous Taman Rimba Kera case. which is also a federal court decision. In this case, the developer was looking to develop a piece of land that was part of Taman Rimba Kiara and the residents around it, because it's a very famous and very beloved park in TDDI. And the residents staying in the vicinity was objecting to this development project. So in this case, we refer this Taman Rimba Kiara case as Datuk Bandar KL against Perbadanan Pengurusan Trellises and other appeals. So normally we call it a short, the Trellises case. So in this case, the mayor of DBKL granted the planning permission for the development of residential property. Neighbors objected on the basis that the development was in contravention of the current structural plan or development plan. So the fact that you want to develop, but unfortunately, what is under the structure plan is open space. So you can't override the structure plan. And hence, therefore, in this case, the federal court held that the planning permission was null and void, and hence the development could not go on. So in this case, I think this is basically a nightmare for all developers, where you've planned, you've expended time and a budget for the development project, to plan the development project, but at the end of the day, but because of this conflict, you are not able to continue with the development. So there are mitigation measures that can be enforced or can be done before you plan or before you submit your planning permission. And these measures need to be done. For example, like I said before, the structure plans and local plans can be amended, but an application needs to be done. And once the amended local plan or structure plan is amended to, for example, in this case, to change public space to residential zoning. After that, when the developer puts in their planning permission for residential development, then this entire situation will not arise. So it can be avoided. But of course, whether or not the structure plan can be amended is subject to approval from state committees, state planning committees, EXCO, and the local committees. Next, this is the Muhammad Yusuf case. I think Joseph mentioned this as well. Failure to provide technical reports to objections prior to the hearing of the objection renders the hearing null and void. So in this case, the local authority usually holds inquiries before approving planning permissions. And in this case, the residents filed an action against the mayor while the inquiry proceedings were going on before the approval of the planning permission, because they said that there was no full disclosure and the mayor was very biased during the inquiry. The mayor has basically breached its duty to act fairly. And since there is no technical reports, this entire inquiry would seem to be like more of a lip service. So at the end of the day, the court held that yes, this inquiry was null and void. You have to redo it again. You have to get in your technical reports, your EIA, your SIA, and even some circumstances, traffic impact assessments need to be done as well, especially if it's development surrounding residential or commercial areas that are already very established. So from this case, that you get all their reports done in time before submitting your planning permission application. Now, the fifth case that I'm going to touch on is Muhammad Suhaili bin Thambi against Datuk Bandar Kuala Lumpur. So in this case, it's a high court case, but nonetheless, still relevant. In this case, the applicant, which is the landowner, went and applied for planning permission to build and renovate a building. So planning permission was granted. However, during site inspection, it was discovered that the building that was built was not in compliance with the approved building plan. So in the end, DBKL asked the landowner to demolish and rebuild, and the landowner applied to challenge the decision. It's like, I've already built it. It doesn't make sense for me to demolish and to comply with the existing building plan. In this case, he also submitted actually an application to amend the building plans after the completion of the construction of the building. And this was rejected by DBKL. So that's why the landowner thinks it's unfair. I've already submitted an application to amend. Can't you just approve my application to amend the building plans, and then I don't have to demolish my structure and, of course, incur additional expenses? So the court upheld the DBKL's decision to say that you have to demolish and rebuild. And DBKL already gave reminders to the landowner to do it, and even issued a compound. So the fact that the landowner even paid the compounds. So even though you paid the compound, you still have to demolish and rebuild. In this case, what we can take away is, if let's say there is during the construction period where you know that some things in the building plans can't be performed, and things sometimes turn out differently. Once you hack or you demolish certain structures, then suddenly you realize your original plan can't be executed. Immediately put in an application to amend before completing construction. So if that is the circumstances, I think the local authorities would be more understanding. But in this case, you don't do it, you don't put your application to amend after you've completed the building. I think that is what the moral of this case at the end of the day. So the court held that approved building plans must be adhered to. Failure to adhere, the authority may order that the building be altered or demolished. Now, in Heavenly Heritage, Sdn Bhd against Majlis Pembangunan, the developer obtained planning permission to develop the car park on plot of land, and planning permission was granted. However, later on, when the developers subsequently wanted to change and develop the land for an apartment, this application for planning permission was rejected. So in this case, it would seem that the history of use of a piece of land is a relevant and material factor when allowing and approving planning permissions. So in this case, I think it would be prudent for the developer or the landowner to make sure you do sufficient feasibility studies, and especially where you acquire lands or where you're a developer and you purchase lands for development. Before purchasing the land, feasibility studies can be made to ensure that the previous use of that land doesn't prohibit your intended subsequent use. So for example, previously this land was used for plantation purposes or agricultural purposes, and you want to develop this piece of land to the commercial district. So the advice is to engage experienced valuers and planners to carry out feasibility studies before you commit or you spend millions to purchase the land, which you later can't develop. So there was an argument of an unused density, but I think in that case, the Planning Appeal Board was still not convinced, and subsequently they still dismissed the application for planning permission. And the last case that we would like to highlight or bring to your attention to is Oi Hoi Bing against Majlis Perbandaran Seberang Perai. So in this case, it's also a case decided by the Planning Appeal Board. Appellant applied for planning permission to change the use of a double-story semi-detached house into a daycare center, which is quite common in Malaysia, a tadika in a residential development. So the planning permission was rejected by the local authority purely due to the existence of objections. This is the local authority's decision. However, when the landowner filed an appeal to the Planning Appeal, the board said that the local authority cannot reject planning permission purely due to existence of objectors. Proper investigation into the objections must be made by the local authority before deciding or to allow or reject the planning permission. I think maybe in this case, the most common complaints we have against daycares in residential developments is actually traffic. So where the parents come and pick up their children during pickup hours and sending them off as well. So in this case, if let's say, for example, you are putting in an application for planning permission, of course, I think it would be advisable to get a traffic impact assessment done before, so that when the inquiry is held and people object to your planning permission application based on all these reasons, that you already have your MO ready. So when objections come, you can easily say that this has been dealt with, and that would increase your chances for your application to be approved. So this is the last case that we are going to highlight. Now, practical tips for successful applications. Main takeaways for today's talk: development plans, local plan, and structure plans, they have a force of law. So you have to engage professionals, experienced professionals, to review the development plans and regulation before applying for planning permission. And if there is any ambiguity or conflicts within this regulation, of course, experienced valuers, planners, they are very well versed with the existing laws and regulations, even though they are not lawyers, but they are very, very familiar with all these regulations. It's their what do you call, rice bowl. But also, if let's say there are any ambiguities or any conflict, it can actually, in order to prevent what happened in Sunrise Gardens case, what can be done is actually, if there is any ambiguity, these professionals or developers can also seek legal opinion from lawyers in interpretation of the regulations and the relevant guidelines or structure plan. Even so, this would, I think, would decrease the chances of your development being challenged by any persons interested. So these are mitigation measures that can be implemented at the beginning of the development project. And the fourth point is to apply to change zoning or local plan or category of land use in the land title before the development. This is also sometimes something that developers usually miss out. So they are very happy, they just got a piece of land and they want to develop and they want to make money. That's the main objective. But take note, regulations and these regulations and structure plans, development plans has to be complied with. Lastly, feasibility studies. You can also look into pollution control measures. Some developments are done near very sensitive areas, for example, rivers. So we have to look into pollution control measures as well, and stability. I think experienced engineers would also advise you on possible modifications in the process on how to mitigate and avoid pollution and of course any other troubles. Last point is to consider environmental and social justice. Nowadays, people, or how should I say, neighbors are very aware of their rights already. We are becoming a more and more litigious society, more educated and more litigious as well. So definitely we have to consider environmental and social justice. ESG is also on the rise. So we do have an inherent duty to protect our environment as well. So these should become your main considerations when planning a development project. So that's all from me today. I'll pass the floor back to our moderator, Jasmine.
Thank you, Joseph and Denise, for your insights on applying for planning permissions, overcoming approval challenges in project development. So we'll move on to our Q&A session today. It looks like there are a few questions from the audience. The first one is from Catherine Lee, and she wants to know, just to confirm that the TCPA 1976, which includes Putrajaya and Labuan, also includes Sarawak and Sabah. I think I'll hand it off to Joseph.
Yes, thanks for the question. The TCPA does not apply to Sabah and Sarawak. So in the preamble of the Act itself, you can see that it applies to Peninsular Malaysia only. The reason why Labuan is included is because Labuan is a federal territory. So the federal government has jurisdiction over Labuan, which is the reason why Labuan is included. And it's also provided for in the Federal Territory of Labuan order that is a subsidiary legislation under the Town and Country Planning Act. So for example, in Sabah, they have the Town and Planning Ordinance. So to answer that question, no, it does not apply to Sabah Sarawak.
Thanks, Joseph. We have one from an anonymous attendee. First, they want to know whether the dilapidation report is compulsory before submitting a building plan approval. And also, is it possible for us to change the use of land simultaneously with an application for planning permission?
I'll start with perhaps Denise, who's more well-versed in construction, can add. It is not a statutory requirement for the dilapidation report, unlike SIA that has been baked or rather put into statute. But as we have seen earlier in the slides, development covers a wide spectrum of works. So the legislation also gives the local authority a lot of power in determining what documents they will require before they approve a planning permission application. So in terms of construction or development that requires the dilapidation report to assess the structural integrity and all that, then yes, it may be required. It's not in statute, but because the local authority is the authority that is approving the application for planning permission, practically speaking, you would want to provide it if it's required by the local authority. And in terms of change of land use simultaneously with an application for planning permission, I assume that it is the change of land use in the title when there's an application for planning permission. Legally, there's nothing stopping you. I mean, in terms of legal procedures, nothing stopping you from doing that. But the local authority may require that the category of land use be changed first before they approve your application for planning permission. Denise, is there anything you would like to add?
No, I think that's all. But it is possible for you to also, I think, put in an application for change of land use before your application for planning permission. I have seen cases where clients apply for planning permission and then the state comes back to, or local authority comes back to say that, oh, you have to apply to change the use as well. So normally, I think it will be advisable to change the use first, then only, and you during in your application for change of use, you can say that we intend to develop or to apply for planning permission for a subsequent, let's say, for example, residential development. So I think then only then your application for change of use would make sense. And I think it's best to get that change approval for change first, then only you put in your planning permission application. I hope that answers the question.
Okay, I will move on to the next question from Marcus Liu. May I ask what's the difference between a structure plan and a local plan? And a follow-up question to that is what are the differences between planning permission and development order?
I think I can answer that. Structure plan is basically a rough plan for use of lands within the state. So structure plan is normally determined by the state exco. Rough plan, again, not as detailed. So after the state determines the structure plan, and once the structure plan is approved, then the local plans, the local authorities, which is your Majlis Perbandaran, will come in and start planning the local plans, which are detailed plans for use of lands within their jurisdiction. So, for example, in Selangor, so you have Selangor, you can have a structure plan for Selangor, and then Majlis Perbandaran, for example, Ampang Jaya will have their own local plan, and a different Majlis Perbandaran or PJ would have another local plan as well. So it's more detailed and you need to comply with both. And if local plans do not comply with structure plan, that local plan can also be challenged. So that answers that question.
What is the difference between planning permission and development order?
It's basically the same thing. The Town and Country Planning Act calls it planning permission, but because these are procedures under the local authority, traditionally it's called development order. So it's actually basically the same thing.
All right, we have another from an anonymous attendee. If the land title is under industrial, but the zoning had changed to residential, can the landowner still build industrial? Would any of you like to, whichever one of you like to take that?
I think the short answer is no. The thing with, as explained earlier in the cases, zoning does trump the category of land use. The thing is with local authorities, as we have gone through a few of the cases, sometimes the local authorities will make exceptions. And the thing is, if the approved development is not in compliance with the zoning and the objections, and there are a lot of people placing in the objections, there's a good chance that planning permission or DO, if approved, may be set aside by the court in judicial review because of the importance of zoning. Denise, anything you would like to add on that?
No, but it's just that this question actually is exactly the case of MMC Tepat Teknik, where the court held that zoning prevails over category of land use on the land title itself. So you have to take into consideration zoning. That is more important than whatever is stated on the land title. The category of use on the land title can also be changed. You just need to make an application to the land office to change it to follow the zoning. So then you can develop that piece of land according to the purpose that is zoned, the use that is zoned under the local plan. That's all. Thank you.
Okay, just one more if you guys still have it in you. For all the planning permission application and case studies presented by Paul, Joseph, and Denise, will it be applicable for projects or land in Sarawak?
The provisions of the statute, the legislation, no, as I've explained earlier, but perhaps some principles can be used by the lawyers in Sabah Sarawak based on legal principles, case law. But if it's really tied down, if the principles are tied to the statute, meaning it's really a question of interpretation of the sections in either the TCPA or the FTPA, then it won't be applicable there.
Well, unfortunately, we have a couple more questions, but it's past 4, and in the interest of saving time, I think we're going to have to conclude here. But before we conclude, I do have a few announcements to make. First, please join us again for our upcoming talk. It will be on the 8th of May, which is on a Wednesday, and the topic will be on the Mandatory Death Penalty Act 2023 and the revision of the sentence of death, as well as the imprisonment for natural life, which is the temporary jurisdiction of the Federal Court Act 2023. So our speakers will be Agaya J. Munusami and also Ketika Padmanabhan. Next, I'd also like for you all to join us in our upcoming Academy talk, which will be titled Corporate Social Responsibility, or CSR for short, Business and Human Rights, on the 10th of May 2024, which will be held from 9:30 to 1:30 p.m. in the Mawingkwai and Associates conference room in our office, with our consultant, Dr. Mao Wing Kwai, who will be the speaker of the seminar. And this workshop will cover all of the essential elements of leading companies to seamlessly integrate ethical practices, translating them into heightened revenues, enhance brand loyalty, and increase market positioning. So don't miss out on this opportunity to gain valuable insights and secure the early bird prize by scanning the QR code on the screen or by clicking the link provided in the chat box. And of course, don't forget to fill out our feedback form and also tell us what you thought of our talk. The link to that form will be posted in the chat. And please also follow us on social media. We are on everything. We're on YouTube, Twitter, Instagram, LinkedIn, and also Facebook. Also, for our complimentary consultation, if you'd like to speak with any of our lawyers, we do offer a 30-minute free consultation over the telephone or over video conference. So please fill in the form again on our website, and the link will be posted also in the chat box. And last but not least, to our guests, thank you so much for joining us today. We hope you found today's session informative and useful. Thank you, everybody. See you at our next talk.